Five, four, three, two.
The designated hour having arrived, I call to order this regular meeting of Ansel Link's Quorum Forum podcast, the podcast local governments need to do business. In the chair, it's me, Daniel J. Bolin. On the agenda today, we're talking about public records on your personal accounts, and then we'll have an explainer on qualified immunity, and it's part of the conversation around recent claims against police. But first, let's take the roll. First, we have an equity partner in Ansel Link. She writes Ansel Link's popular Municipal Minute blog. She's doing her best to survive the pandemic, and we're going to ask her about it. Julie Tappendorf is here. Oh, Julie, you're on mute. This is the classic sign of times.
How many meetings has that happened? Yes, present.
Every single one. So, Julie, we've talked a lot about COVID-19 on this podcast, and unfortunately, there's another pandemic underway this season. It's pumpkin spice pandemic. It's everywhere. To help us get through it, would you please tell us what's actually good that's pumpkin spice? What's your favorite pumpkin spice anything?
Well, I don't like PSL, the pumpkin spice latte, so I'm not looking forward to that or waiting for it to come out, or maybe it already is. I like pumpkin seeds. Do those count?
Oh, those do count. I think it's more natural than the artificial pumpkin flavored products that are taking over. For me, the best pumpkin type tip that I got was actually in law school. My contracts professor recommended pumpkin pie, but if you instead of evaporated milk, you use ice cream, and it makes for a very fluffy, rich pumpkin treat. So for all you pumpkin fans out there, you heard it here first. Pumpkin seeds and pumpkin pie. Get ready. It's that time of year. Next, we have a litigator in Ansel Link. She represents municipalities, school districts, and private clients in general tort litigation, employment actions, and civil rights claims. She's been going to court on Zoom, much like this, and we're going to ask her about it. Kathy Kunkel is here.
Yep, here. Hello.
Hello, Kathy. Well, tell us what it's been like. What's it been like going to court online?
Right. I have made a few appearances in court by Zoom. It's been a little weird. There is a learning curve there. Some attorneys have had, kind of like green screens in the background with pictures of Paris or other places in the background. And I'm like, oh, these people are so, technologically adept, not me. But yeah. So it's been interesting.
Oh yeah, we gotta like think of some like good virtual backgrounds to take with us to court. That could really change the game. Like a real fancy office, look like we're in a real prestigious study or something. Like really impress everyone when we go to court. That's a good idea. But We'll see what you come up with. Maybe you'll throw up a virtual background on this call. We'll see. You do have a nice background. Nice backgrounds to everyone, to the listeners at home that are listening on the podcast and not on the live stream. Kathy's got like some fabulous artwork behind her, and so does Julie too. But the one's more abstract. Kathy's got the abstract piece, and Julie's got a nice like woodsy photo behind her. And let's see here. We've got also speaking of the stream, a bunch of folks here today joining us on the stream. Thank you for joining us. I hope you are all healthy and safe wherever you are, and I mean that sincerely. Not like when people say, "I hope this email finds you well." I encourage you to share your questions with us, and we'll try to get in the chat. And or email us always at podcast@anselglink.com. We'll try to get to as many questions as we can, but as always, we're not giving legal advice. If you need legal advice, go talk to your attorney. Behind the glass, a virtual glass for our protection, is Engineer Rick. He is present. We have a quorum. First on our agenda, public records on personal accounts. We've talked about public records on this podcast before, dating back to episode number 1. Julie Tappendorf was there, but there's a recent appellate court case on this subject, so we're delighted to welcome her back to talk about it in a segment we're calling New FOIA Who Dis? Public Records on Personal Accounts. So Julie, maybe we should start at the basics and remind everyone what is a public record.
Right. So welcome, especially to those of you who may have been here for our first podcast, because this was the exact topic we talked about. Episode 1, now we're full circle, episode 43. And thanks, Dan, for inviting me back for this with this new case. So just to start from the beginning, those of you are all familiar with what FOIA is, Freedom of Information Act. That basically is the half of the sunshine laws that apply to government transparency. So FOIA requires, for the most part, that public records be available and be accessible to the public. Open Meetings Act, which I'm sure we'll talk about in a later podcast, relates more to the meeting side of things. Today, we're going to talk about FOIA. And there are two issues really that end up being the most critical in determining whether a record is subject to FOIA. In other words, is it potentially releasable to the public? The first is it a public record? So the first thing we look at is the record that's being requested a public record, because private records, personal records, records that don't pertain to the transaction of public business are not releasable under FOIA. I know that people sometimes get concerned about that. They may use their government email to email their teacher or their vet or whatever it is. Those emails are not subject to FOIA. A public record needs to be some record that relates to public business, so the business of the public body. For those of you working in municipalities or park districts or school districts or township, the record needs to discuss business of your government entity to qualify as a public record. So that's really the first inquiry when you get a request is the person even requesting a public record? If they are, that record and what we're going to talk about today with these cases, that record needs to be in the possession of or under the control of a public body for it to qualify as a public record. So it's not just that it relates to the transaction of business, but does the public body actually have the record? And it doesn't necessarily need to be on the server, which is what we'll talk about in these cases, say if they're asking for an email, but it needs to be in the possession or under the control of. And that second piece, Dan, and I know you're going to ask me the questions, I'm going to jump right in, which is, what is a public body? Because if the record has to be in possession or under the control of the public body, then what does that mean? Who's the public body? Well, there's no question that the local government entity is a public body. The public body, the legislative body is a public body. The administrative and quasi-judicial bodies, so, plan commissions and that sort of thing, are public bodies. But the real issue is an individual who is an employee or an officer or official of the public body also subject to FOIA? And, sort of giving away what we're going to talk about. But that's really the issue that keeps coming up in these cases when we're talking about, and this is the title of our session, public records on personal accounts, whether or not that record that may qualify for part of the test for a public record, so it talks about public business, whether it's in the possession or control of the public body as an entity. And that's what the courts have, and the Attorney General's office has struggled with.
Right, because actually, right at the top of the Freedom of Information Act, it talks about how the changing technology, they can't legislate for it, and acknowledges that the Freedom of Information Act will continue to apply as this as technology changes, and we've kind of watched that as the way that people use devices and do their public and private business have changed over time. But kind of the first time that this was really addressed by courts, and I don't know if it's a landmark case or whatever, but it was the Champaign v. Madigan case back in the early 2010s. Take us back to before times, Julie. Remember
pre-pandemic
when we could go to public meetings and in somewhat normal conditions, but that in that case, City of Champaign reporter goes to the City of Champaign council meetings, study sessions, watching elected officials texting and tweeting each other from the dais, and makes a request for those records, whether or not they're on personal devices or on public devices. What happened in that case?
Yeah, so it is interesting from a fact standpoint, because here we have a reporter who is watching the city council meetings or attending these city council meetings, and the reporter can see that the city council members are sitting up there and texting each other. So and I always think about back when I first started practicing and sitting at a city council meeting, people weren't texting or emailing each other, but you can bet they were passing notes back and forth, the city council members.
Mm-hmm.
So this is the new note passing. Well, what do you think? And those of you on the call here who are FOIA officers, you've probably seen a few of these emails or text messages if there's been a FOIA request. And they're not always flattering, or in some cases they may be embarrassing to whoever's sending these or receiving them. And there is no, as you all know, there's no exemption under FOIA for embarrassing text messages or emails. So I don't know what exactly they were texting. Maybe they were even texting about the reporter. Who knows? But there were texts back and forth. The reporter asked for them, filed a FOIA request. The city denied the request, not because they were exempt. They certainly or could have pertained to the discussion of city business and business of the city council, but they denied it because they said they weren't public records, because they weren't in the possession of or under control of the public body, which is the city council or the city of Champaign. I thought it was a good argument. I think, back in the day, that I would have made the same argument. I think many of us would have, that listen, these were on private devices, personal devices, cell phones of the city council members. The city council members did not get a stipend from the city for their personal devices. So those devices were not under the control, or certainly not under the possession of the city council. So that case, it first was, and the reason it's Champaign v. Madigan is the first thing the reporter did was not file a lawsuit when the request was denied, but took it to the attorney general. And that was the public access counselor, who it's one of the two ways that you can challenge a FOIA denial. And the attorney general issued an opinion in that request for review, finding that basically it doesn't matter what the device is. So whatever the device or the count that's used is irrelevant. That if a communication relates to public business, it is releasable under FOIA unless an exemption applies. And that was it. It was a very hard and fast rule. So the city, it was a binding opinion, which can be appealed, and the city appealed it to the circuit court. And eventually it made its way up to the first district appellate court. So that first level of appellate court review. And so the appellate court looked at this appeal of what the attorney general had opined, so this binding opinion, and walked it back a bit. And we say that there was this attorney general opinion that it doesn't matter how you send it, where you send it. If it's public business, it's releasable. And that's not what the court said. The court went through an analysis of really looking at the definition of public record And that prong, not just that it relate to public business, but that it also be in the possession or under the control of the public body. And the court said, in this case, in these circumstances where the city council members are texting each other at a meeting, that those text messages would be subject to FOIA. And the reason being, there was a quorum at the meeting. The city council members were acting as a public body because they were meeting. So of course they were acting as a public body. And so their communications while there was a quorum present and while they were acting as a public body were under the possession or under the control of the public body. And so they had to be released. So really what the court did is walked back what the Attorney General's opinion was and said, there are three circumstances, and we always call this three prong test, or three different circumstances where a email under on a personal device or a private account would be subject to FOIA. And that would be, one, if you're at a meeting. So in this case, the public body is at a meeting. Two, if it's sent to a quorum of a public body. So again, it's kind of the same thing. You're acting as a public body. Or three, if the message is forwarded to the government account, which of course it would be. That one's easy. If it's forwarded to the government account, it's on the server, it's on a government device. So that's where Madigan, the Champaign-Madigan, and we've been operating under that test for some time. So it hasn't been the case that every email or text message that relates to government business is FOIAble. It's only under those circumstances. And that's where we were, at least at that point.
Right. And that's been the highest level decision that's applied throughout the 20 teens. And here we are. But there were some public access counselor opinions and even circuit court opinions kind of percolating up over the years, kind of pushing the boundaries or that were factually different than the Champaign v. Madigan case, and that kind of led us to this most recent case that came out last month. That what we're here to talk about today, the Better Government Association versus the Chicago Mayor's Office. What kind of led us to get there, and then what happened in that case?
Yeah, so we haven't had any other appellate court decisions until the BGA case that just came out. But there have been some attorney general opinions issued, and there were a couple of circuit court cases, one involving former Mayor Rahm Emanuel and his text messages. Another circuit court decision involving the Laquan McDonald shooting, and there was a request by a couple of different news stations for the text messages that the police officers were sending during the incident. And in both of those circuit court decisions, the one involving the former mayor and the one involving the police in the shooting incident, the circuit courts had determined that that at the time that those messages were sent and received, that the mayor and the officers, again, two different opinions, but the analysis was the same, that they were acting as a public body. And so in that case, it met that second part of the definition of a public record. Neither one of those cases made their way to the appellate court. So I believe in both cases, the city of Chicago provided the records. So they didn't appeal it, and they just simply complied. So none of those made their way up. We were still operating under Champaign v. Madigan. It's interesting, though, the attorney general opinions that have come out since that case, where when we think about Champaign v. Madigan, the ruling by the appellate court really did narrow what the attorney general's opinion was. So the attorney general has not wavered from that office's opinion that it doesn't matter what device or account, if it relates to public business, it's FOIAble. They haven't moved from that. So even with Champaign v. Madigan, an appellate court telling them you're wrong, this is not the test, they were still, and I've read a number of opinions from the attorney general's office, the PAC office, that have made the same argument. Doesn't matter what device, it's FOIAble, if it's public business. That's where we were. That's where the Attorney General is, and where some of the circuit court decisions were going that may have led up to the BGA case, which also involved the city of Chicago. So we see a lot of these rulings come back to, hey, what's going on at the city of Chicago, which is affecting so many of us now because of this first district ruling.
Right.
So just to dive into the BGA case,
Sure.
This involved a FOIA request. It was, I think, 3 years ago. So, as usual, these cases take years to resolve, even though the decision just came out. And it involved a FOIA request for records from the former mayor's office, so Mayor Rahm Emanuel, and also from the Chicago Department of Health. So there were a records request, a FOIA request filed for text messages and communications of the mayor's office and of certain city officials in the Department of Health, the city Department of Health office. And the city did provide a number of records in response to the request, but the city didn't ask the officials, the specific named officials in the request, to turn over any emails or text messages on their personal devices. That's when the BGA challenged this. They filed a lawsuit in the circuit court to challenge the city's response. So the city didn't deny any part of the request, so it wasn't a challenge to a denial. Basically, what the BGA was arguing is the city did not conduct a reasonable search of records, which is required under the Act. It's one of the obligations of public bodies that when you get a request, you're supposed to conduct a reasonable search of your records for responsive records. And the challenge in this case was the city didn't do that because they didn't contact the individual officers named in the request and ask them to turn over emails or text messages, or even ask if they had any. So that was the real crux of the challenge. It made its way up to the First District Appellate Court, which is a different district than the Champaign case, because we're talking about Cook County and the city of Chicago. And the decision that came out recently sort of strayed, in my view, from Champaign v. Madigan, but does match where the Attorney General's been going and where the circuit courts have been going on this issue. And basically what the appellate court found was, again, there wasn't a denial of a request. The court found that the city of Chicago did not conduct a reasonable search of records because they didn't reach out to the individual officers and ask them whether they had any responsive records on their personal cell phones or their personal email accounts. That was the issue. And so in essence, the city was in violation of FOIA, not for not turning over the records, but for not even asking and not doing a search for the records. That was the holding. But I think what the main point in the case, and again, we sort of started with Champaign v. Madigan, which was a much more limited, and maybe even we started before that where we thought, hey, if it's a personal device or my Gmail account, how does the city have any control over that? It's certainly not in their possession, so it shouldn't be a public record. That's where we started. Champaign says, well, in some cases, it will be a public record. And now in this decision, in essence, what they're saying, and the court went through an analysis of that definition. Again, we keep going back to the definition of public record as to what control of the public body was. I don't think that the case and the law has gotten so far as the Attorney General to say the device doesn't matter. This case is pretty close to that. But really what this case stands for is, depending on the nature of the individual's job duties, right? So what are your day-to-day duties as a public official? In this case, the appellate court found that the mayor's office, the individuals named at the mayor's office, and the director of the Department of Health, that these city employees, because they could make independent decisions on their own, could be acting as a public body, even outside of a meeting because we're not talking about legislators where they can only act as a quorum, that some of these executive level officials and officers could be on their own individually considered a public body, depending on when the message is sent and what they were doing, kind of like the police officers in the Laquan McDonald shooting. That's what the case turned on, that these named individuals could be acting as a public body. So their records would be under the control of the public body because they were the public body. To me, it's a stretch. I mean, quite honestly, that's not how we define a public body as an individual. I think that there's a fairly good argument that a mayor has executive powers that don't need to go to council, and that there may be opportunities for the mayor to act on behalf of the public body. It's hard to see how other city officials have that authority, but that's where we are. So we have a case, very recent case, an appellate court case in Cook County. So it's in the 1st District that says that it I won't say it doesn't matter what device it is, but I do think that we're getting close to that the courts are looking at, and again, it's not just about the definition of public record, which I think is really critical. But Dan, you mentioned at the beginning the purpose of FOIA and sort of the introductory message paragraphs to FOIA. And we have to remember, because the courts don't forget, that the purpose of FOIA is transparency in government. And so the court in this case spent a lot of time talking about, what if we didn't hold this, right? What if we ruled in favor of the city, that city officials could in essence use their private cell phones, their texts, text each other, use their Gmail accounts, whatever, to discuss public business, and the public would never see that. That actually, you may remember, that was discussed in the Champaign-Madigan case, and the court said, sure, we understand that, and we should all be concerned about that, but that's what the legislature's for.
Right.
So if we need to change FOIA and make that clear, then the General Assembly should pass a law and modify FOIA to say that emails and text messages on personal devices are subject to FOIA. It doesn't say that. That's where Champaign-Madigan went. The BGA versus City of Chicago, a little bit different. They spent a lot of time being very concerned about government officials hiding what they're doing. And so I think that may be the main reason why the decision came out the way it did.
I think both cases came out the way they did because of the facts and the way that they were in Champaign. They were at the meeting, and so yeah, this is a quorum, like trading messages. So these got to be public records. And then this one, in the BGA and City of Chicago case, I think they were really, the court really went in on, the reasonably diligent search, and like what it was reasonable that they would find public records on these on these private accounts based on the facts laid out in the case. And so it wasn't a reasonably diligent search. And the court was really went in on that they didn't ask, and that they didn't look for them. So both cases got kind of the facts that we have to live with now. What should I mean, this kind of, we've been living with this trend for many years, and kind of helping local governments manage their public records on whatever devices they use. What are some things that local governments can do to help manage their public records on whatever devices where they may be?
Yeah, so I think about this as best practices. We have different cases with slightly different outcomes. What's a good best practice or best practices for local governments, for public bodies, to avoid maybe the third case, so a different decision, and we certainly wouldn't want to see it for any of you. So a couple of things to think about and ways to avoid this type of situation. And for those of you that are FOIA officers, to make your lives a whole lot easier. Number one is to encourage all of your public body, public officials, public employees, officers of the local government to use the official accounts and their official devices, so their government accounts and their government devices, to talk about public business. Because the less you entangle your personal account and devices with government business, the less concerns and issues and legal problems that'll come up. Plus, administratively, for the FOIA officers, and especially considering this case dealt with what's a reasonable search for records, you're putting your FOIA officer in a really tough spot to say they have 5 business days to respond to a request. And now they've got to go to each individual city official and officer and ask them to turn over their text messages and turn over their emails for whatever time frame or scope of the request, review those, determine whether there's an exemption. Where if the government officials and employees were instructed to use their official devices, they'd just search the server. It's a much, much easier and a less administrative burden. And frankly, I can give you an example of, and I think I use this example because it still sticks in my mind. I think I used this in episode 1, that I had a client who had a FOIA request for text messages between the city council members, kind of like this case, but they wanted text messages between the city council members on a particular matter. And they didn't have the phones. It was text messages and emails, and the emails were the critical piece. So this city council at that time, this was a few years ago, were all using their Gmail or Comcast or whatever accounts. They didn't have an official email address for any of the city council members. So when there was a request for the public records, for these records, we had to go to each individual city council member, send them the request and say, okay, for this 3-month period or whatever, 6-month period, you have to send us all of your emails and text messages about this particular topic. These guys spent, and ladies spent their entire weekend pulling these records together for this FOIA request so that then they could be reviewed and then redacted for exemptions and turned over. And after that, after spending and ruining their weekends going through their own phones, right, and their Gmail accounts, they decided, and there had been a push before and nobody was interested, but they decided, hey, we want an official city email address. We never, ever want to have to do this again, right? Next time you get a request like this, we have our own city email account. That's what we use to communicate. And now IT can just run a search and staff can look through the emails and they don't have to ruin their weekends looking through. So for those of you that are thinking, how am I ever going to get my council members or board members to switch over and use their official accounts, let them know what it means to use their personal account. That means that you're going to contact them and you're going to have them look through and pull out, do the search and pull out all those records and send them. They aren't protecting the confidentiality of those records by using their Gmail account, as we've seen, because there's been this movement towards, doesn't matter what the device is if it's public business. So first is, let them know and everybody that it's strongly recommended, encouraged, and you could even adopt a policy. I've seen a couple of public bodies that have adopted a policy to require use of the official accounts and official devices when you're engaging in public business, and that eliminates that issue. We don't have to worry about going to the personal devices. 2, if inadvertently they are using their personal accounts, maybe a resident emails them on their Gmail account or at their work address, have them routinely forward those to their either they could forward them to the manager or the director, or forward them to their own official account so they're on the server, and just get into a routine. If they're going to respond to a resident, have them use their official account, even if they're emailed on their personal device. And then third, to the extent that you have officials and employees using their personal devices, if you get a FOIA request for records for communications, based on this BGA case, you can't just assume that they're only asking for records on the server, on the account. This case says you have to do a reasonable search, which means reaching out to the employees and the officers who are named in the request and saying, hey, can you do a search of your personal accounts and check and see if there are any responsive records? And if there are, you need to turn them over. I think that hopefully if you've employed 1 and 2, they'll say, oh no, I don't have anything. And you'll be good. And then if there is a challenge, you have the record that says, we asked, there wasn't anything, or we've already turned it over. And I think those are some tips for best practices. And again, I mentioned you could adopt a policy. So the public body could adopt a policy that you have to use your official devices. And I think that's something, it's not required or mandatory, but it's something to consider.
I know many communities do adopt a FOIA policy, and you hear some local governments are like, "Oh, we don't need a policy; we'll just follow the law." Well, this could help you. A policy could help you find ways to make it easier for you to comply with the law. And think of the poor FOIA officer and their ruined weekend for having to go find these records wherever they are. And you see some public officials or elected officials and staff, sometimes they use 2 phones or 2 devices to help keep their public and private messages separate, and set themselves up for success for a future a reasonable search and make it easier to accomplish that someday. But if you get public records on the personal device or otherwise, shoveling them to the right server so that they'll come up in a reasonable search someday is good advice. Any final thoughts on the public records on personal devices? But before you got to go, I understand there's probably a pile of FOIA requests out there to go help folks with.
Yeah, there are always a pile of FOIA requests, as I'm sure those on the call would attest. So again, the best practices I think are good to take back. It's not just about FOIA too. When we think about having records on the public server or the public account, it's also a records retention issue. We're not going to get into what the Local Records Act requires and what your records retention policies are, but the fact that these records could be required to be preserved in some way, and how are you going to make sure that they're preserved? And I'll tell you, when we had that very lengthy and large FOIA request that the alderman had to go through in this city for the response, Gmail, one of the settings on one of the alderman's account for Gmail was to automatically delete records after 90 days. Once they're gone, sure, under FOIA, you're fine. You can say, hey, no responsive record, but are you now in violation of the Local Records Act? So I think they work hand in hand. And so it's not just about having the records available to respond, but also about retaining the records to the extent you have to. And if the public official is going to insist on using their own account, then how are they going to retain them to make sure you're not in violation of the Local Records Act too?
Good thoughts all. Julie, we got a quick question here from the chat. I'm having trouble understanding what, quote, all records falling within a category, end quote, means within Section 3G of the FOIA Act. What is roughly the line for the unduly burdensome threshold? Does it help here? So 3G says requests calling for all records falling within the category shall be complied with, this compliance with the request would be unduly burdensome. Where's the line?
Yeah, so this comes up a lot. In unduly burdensome, we look at it, it's sort of like an exemption, but a little different than the exemptions that we think of under Section 7 and 7.5 that allow you to redact or withhold. But it is a tool. So it's a tool under FOIA to deal with a request for a categorical request. That's what the issue is. If it's a categorical request, for a significant amount of records or documents, that you can deny it as unduly burdensome as long as you follow the procedure. And that procedure means you have to reach out to the requester and ask them to narrow the request before you deny it. That is which isn't part of your question, but I think it's important for everyone to understand. You can't just deny it and say unduly burdensome. We don't have enough staff to do this. You've got to reach out and say, this is unduly burdensome because it requires the collection. It's a categorical request that requires the collection of, let's say 10,000 records to review and have, review for exemptions and redact and all of that. So that's the process. And if they don't narrow it, or they refuse to narrow, or they don't narrow it enough, then you're entitled to deny it, citing this exemption. But the question, and it's a good one, relates to what's a categorical request that would qualify for unduly burdensome. So I don't know that there's a easy definition, and in fact, it's not defined, but I think examples help. So a categorical request might be, I want all emails between the city council members for the last year. I mean, that could be, it could be one record, or it could be, tens of thousands of records. We don't know until we go and look. But that's a category. So a category would be all emails. Or let's say I want all records relating to the downtown TIF project. Okay, so no time limit, every single record that relates to a particular a topic. So it could be all of one type of record, or all records relating to a topic, but it's a category: emails, records, agreements, that sort of thing. That's the categorical request, as opposed to saying, I'm asking for X, Y, and Z record. I'm asking for minutes from the January 1st meeting and a copy of the ordinance. That's not a categorical request. You're not asking for all records within a particular category. The second, I think, follow-up is, how many records is so many in a categorical request that would be unduly burdensome? Where do we draw the line? And there isn't any number in the statute, or even in the cases that says it's a one-size-fits-all number. And there are cases on this issue, a couple of cases, and there are some attorney general opinions that provide help. And you can probably find a couple of them on the Municipal Minute blog. Maybe do a search for unduly burdensome. The one case that always comes to mind is a case involving the Attorney General's office that said that 9,000, this is why I always think, if it's more than 9,000, you're good. Because if the Attorney General found unduly burdensome a request for 9,000 records, right? And they're the office that enforces FOIA, and they thought that was unduly burdensome. And they have a staff, like a whole stable of FOIA lawyers. And if that was unduly burdensome for them, I think any local government would be fine using 9,000. Does that mean that that's the only, and the court upheld that, by the way, and found that that was unduly burdensome? Does that mean that you have to have 9,000? Absolutely not. The court and the Attorney General looks at how much, what is the size of your local government? How many people are responsible for complying with FOIA? If you have one part-time FOIA officer and 3 employees in your township, that's going to be unduly burdensome. Is going to be very different from you than if you're in a city that has multiple FOIA officers for each department and has, thousands of employees. right? So unduly burdensome for a township could be a few hundred of records. Unduly burdensome for a city might be a few thousand. You really need to consider, and part of your request to narrow has to go into, how is compliance with this request going to affect my public body, not any public body, but it's very fact specific. So if you have a part-time, or you have one FOIA officer who also serves as the clerk, and they're in the middle of election duties or have any number of other FOIA requests, then you can explain all of that in your request to narrow. You've asked for records that look like it'll require us to review 5,000 records based on our initial IT search. We're asking you to narrow it. We have very limited staff. This happened a lot during the early parts of COVID.
The pandemic, yes.
Right, because so the offices were closed. And so how do you get these records? And you have very limited staffing and resources. So the Attorney General actually issued some guidance saying you could use the unduly burdensome during COVID to first try to narrow it, or use it to get additional time. So hopefully that, I know that it's not a hard and fast rule, but hopefully it helps to understand that it really is going to be specific to you and, everything else that you have going on, and your ability to narrow that request.
It's incredibly fact dependent. You don't want to be the case that explains what unduly burdensome means for everybody else. It's probably good to reach out, like they tell you to do, and maybe help narrow that request, and everybody wins and gets the reduce the size of the request, and maybe get the requester what they're actually looking for. So good advice, all. Julie, that 5 days is ticking on those FOIA requests that you've been talking about. And but we'll say goodbye to you and move on with our agenda. Thanks, Julie.
Thank you, everybody. Enjoy the rest of your afternoon.
Thank you.
Bye-bye.
Moving on, recent claims against police have folks talking about qualified immunity. We've sadly all seen horrific videos of Jacob Blake and George Floyd and others in the news. Maybe a court will one day find that that police conduct is a crime, maybe not. On the civil side, maybe a court will decide that conduct is unconstitutional, maybe not. But some are looking to transform recent protests into policy. One common proposal is to limit or abolish qualified immunity. And folks, you might be wondering what that even means. So we brought in an Ansel Glink litigator to explain what qualified immunity is and what it means for local governments. Kathy Kunkel is here. Kathy, where do we begin? Maybe the place to start is Section 1983. What's Section 1983?
Right. So when people say Section 1983, what they're referring to, or what that means, is a particular section within the United States Code, and it's 42 USC United States Code, Section 1983. And what Section 1983 does, it establishes the right or the ability for a person to sue civilly, seek money damages against state actors, or an actor or actors, for the deprivation of their rights, either under federal statute or under the U.S. Constitution. It applies only to individual defendants. So under Section 1983, a person is not allowed to sue the government entity, but they sue the government actors individually, right? And there's a related section, Section 1988, which allows that if a plaintiff prevails under Section 1983, they are they're going to be awarded attorney's fees. So that's kind of the general lay of the land for Section 1983, and that's what Section 1983 means.
Yeah. So the two allegations from what I've read that you need to state a claim, there's that deprivation of a constitutional right, or that federal statute you meant, or federal statute that you mentioned, and it was done Correct. Under color of state law.
Correct.
So that's and this This applies outside
Right.
the police context too. This is the whole dang Constitution. It's all that any kind of claims, all over. So so that's kind of the backdrop. Now what is qualified immunity? Where did it come from?
Right. So given Section 1983, qualified immunity is relatively easy to understand. It was first established or first applied in a 1967 case by the U.S. Supreme Court called Pearson versus Ray, and it's at 386 U.S. 547. And again, that was the first time that it was officially applied. There, the U.S. Supreme Court said, yes, these police officers are entitled to qualified immunity. They were granted qualified immunity for an arrest that they carried out because it was executed in good faith and they had probable cause to support that arrest, right? And that's really what's at the heart of qualified immunity, right? Is that the government actor, the state actor, has a good faith basis for what they're doing. And I can get into more of that in a second. Well, how about right now? So qualified immunity applies, right? This is, kind of the legal justification for qualified immunity. And it applies when government actors, government employees are performing discretionary functions, right? So they're using some sort of judgment about what to do. It does not apply if their conduct, the state actor's conduct, violates a clearly established statutory or constitutional right of which a reasonable person would have known, right? So I tend to start thinking about qualified immunity about like what's obvious, right? Back to that Pearson case, right? If an officer has probable cause to make an arrest, that's a clearly established right? The Fourth Amendment protects the people from unreasonable searches and seizures, right? A warrant, presumably, a warrant satisfies that probable cause element, right? Because you have to have probable cause to get a warrant. A warrant makes a search or a seizure presumably per se reasonable, right? If you don't have a warrant, then that search or seizure is per se, or at least at the get-go, unreasonable. But it can be reasonable if the officer has probable cause, right? If they witness a crime being committed in front of them, they have probable cause to arrest that person for committing that crime, right? So that's kind of obvious. A police officer who arrests somebody without probable cause, that's a violation of a clearly established right ever since the Fourth Amendment was written, right?
Back to the beginning, right?
But right, yeah, right. And I'll say this too: there's a two-part test for whether qualified immunity will not apply. A plaintiff has to show that there is a constitutional or statutory violation, right? That their statutory or constitutional rights were actually violated. You have to have that. And that the right was clearly established at the time, again, such that a reasonable person would have known that his conduct was unlawful. And that's where the issues of qualified immunity come up, is that if the right was not clearly established at the time, or whether the conduct, it's not so obvious that the conduct would violate that person's federal or constitutional rights, right? And as a matter of public policy, again, we tend to think of qualified immunity as applying to police officers, but as you pointed out earlier, Dan, it applies to any government actor. It can apply to schools and their employees. It can apply to hospitals and their employees. It can apply to park districts, libraries, any government entity. But, as a matter of public policy, we want our government actors, and particularly law enforcement officers, we want them to act without fear that they cannot act, right? So especially law enforcement officers, they have to sometimes act or react or intervene very quickly. They have to sometimes make split-second decisions. And we want them to be able to do that without fear that they will be sued later, or, oh, I don't know, is this action, a violation of clearly established rights? We want them to be able to intervene quickly. And it should be noted that qualified immunity is not just immunity from liability, like a finding that, yes, you violated my constitutional rights. It's also an immunity from suit. So the idea being that you want to raise qualified immunity as a defense as early as possible, because you can cut the legs out of that suit early on, and the government entity and its insurance company, if there is one, doesn't have to pay for the defense of that suit. And so it tends to, it tends to, I don't know, put a stopper on a lot of frivolous lawsuits, right? And as a matter of public policy, that's what we want to do, right? We don't want our government entities to run out of money defending frivolous lawsuits. If qualified immunity applies, and plaintiffs' claims could be precluded, right?
Right. Well, and that's part of the ongoing policy debate. But I think there was a recent Seventh Circuit decision that kind of talked about that point, how qualified immunity, you could raise it at the first stage, the pleading stage, when they first file the lawsuit, before you get into a lot of discovery, and then you can raise it later on in the case at the summary judgment stage, which is when you can end the case before trial, but that's after discovery, and it's based on the discovery typically.
Right.
So what was this recent Seventh Circuit case? Can you tell us about it?
Right. So the Seventh Circuit case is Hansen versus Levan, Levan. The opinion came out on July 21st, 2020, so just a little over a month ago, and it's case number 19-1840. And in Hansen, plaintiffs there were deputy assessors within the township's assessor's office, right? So they were kind of lower level clerks, if you will. Their jobs were very administrative. These plaintiffs, they supported, so the defendant Levan, he was the elected assessor. Election for that assessorship, or that assessor's office, in the election, these plaintiffs supported his rival or his opponent. And when Levan came in and took office, all these plaintiffs were fired. And Levan filed a motion to dismiss the plaintiff's complaint. Plaintiffs brought a complaint for retaliation based on their First Amendment exercise of their First Amendment rights, right? They claimed that they were fired purely because they supported Levan's opponent in the assessor election, right? They were fired for retaliation for doing that. Levan filed a motion to dismiss, and he argued that he was entitled to qualified immunity. District Court said no. Seventh Circuit affirmed and also said no. They both said Levan was not entitled to qualified immunity. Generally, government employees may not be fired for political affiliation or exercising their political rights, like the plaintiffs did in supporting an opponent. Usually, generally, government employees cannot be fired for political activity. But there's an exception. There's an exception to that called the Elrod Bronte exception, established by the United States Supreme Court, where if you have officials, government employees who are higher up, right? They're policymakers. They assist the elected official in carrying out that elected official's platform or policies, or political platform, if you will. Then those people can be fired. They can be terminated based on their political affiliation, and it doesn't offend their First Amendment rights, right? So I typically tend to think of like, in a city, you might have a mayor, and then the mayor hires the chief of police, And if the mayor has a political platform like, we're going to be tough on crime, or we're not going to prosecute possession of marijuana crimes as harshly anymore. This is the mayor's platform. Chief of police, I'm looking at you to help me carry out these policies and these platforms. And the chief of police, who is appointed usually by the mayor, or if the chief of police is appointed by the mayor can turn around and say, hey, chief of police, if you're not helping me carry out my political platform, you're an appointed position, you're the highest position in the police department, and you are a policymaker, then yes, that chief of police can be terminated without his First Amendment rights being offended under this Elrod Bronte exception, okay? So Levon tried to argue that these deputy assessors, their political affiliation was important for their job functions, and that's why they were fired, and they fell into this Elrod Bronte exception. But the court said no. The district court and the Seventh Circuit both said no. These deputy assessors were pretty low level. Again, they were kind of clerks, just very administrative type job duties. They were not making policy. They were not policy makers. They were not actively, helping the assessor to carry out his political agenda or his policies. And so qualified immunity did not apply. The Seventh Circuit said that the defendant, the assessor, he should have known, he should have understood that firing these deputy assessors would have violated their First Amendment rights, which were clearly established at the time. And so, the Seventh Circuit agreed with the district court that Levon was not entitled to qualified immunity. And again, to your point, yes, this was a motion to dismiss case. And just as a practice point, I feel you may not win on qualified immunity on a motion to dismiss, but I always like to at least raise it at the motion to dismiss stage, so that everybody knows, the court knows what the issues are going to be. And if you can get out on a motion to dismiss based on qualified immunity, of course, great. As we talked about, it's immunity from suit. So,
Right. And the idea is to protect individual government employees from changes in the law. But in that case, at least based on that record at that stage in the litigation, it would look pretty clearly established. And that case again demonstrates that this doesn't just apply to police; it applies all over. Some folks want to abolish or limit qualified immunity. What would that mean for local governments?
Personally, I think it's not an overstatement to say that it would be detrimental, both for the individual employees and for the government entities, and for us, all of us. Again, particularly law enforcement officers and others who have to interact or intervene quickly, maybe even firemen or EMTs, if the city or the town has its own fire department or its own, they dispatch EMTs for ambulance purposes. These types of people have to make split decisions about how to act or react or intervene. And I think it would definitely affect their ability to do that, and their willingness to do that. I mean, I think without these protections, cities and towns and governments may have a hard time getting people to sign up and agree to be police officers or EMTs or firemen. It might diminish the numbers of people who are willing to apply for those jobs. And I think it would really deplete government resources. Again, these governments and their insurance companies would spend a lot more money defending sometimes frivolous lawsuits. But if qualified immunity is reduced in scope or abolished altogether, then I think there would be the floodgates would kind of open, and the government entities and their insurance companies would be then on the hook to kind of defend these suits, forever, not forever, but, on and on and on. Their premiums would go up, I would assume. Coverage might change. And I think all of our taxes would go up to fund that. So I think, I understand people's arguments, but I think it would be really, really detrimental to everybody.
Well, you are a defense attorney, so of course you would say this, but
right.
Some people think that differently, and that the local governments should be exposed to more lawsuits and so on and so forth. But I think that the short answer is that there would be more liability exposure to local governments if qualified immunity was limited or abolished in any way. So, but as we talked about, it applies to lots of different government employees. It doesn't always apply, and so I think any final thoughts about qualified immunity before we move on with our agenda here today?
I don't think so. I think we've pretty much covered the basics. And I think the thing to remember, although we tend to think about it applying to law enforcement officers a lot, it doesn't just apply to law enforcement officers. As Hansen,
right.
It applied, or it could have applied in that assessor employment context, but it can apply to any government entity employee. Again, teachers, doctors, nurses, library employees, park district employees, anybody. And it doesn't necessarily have to be in a law enforcement, Fourth Amendment context. So, yeah.
Good thoughts. Thank you for the explainer. Hopefully that helps people have more informed conversations about qualified immunity in their everyday affairs. But it is a regular meeting, so we do have to have public comment. So let's look at one of our questions that we get. We have a number of employees who have children who will be attending school remotely this year. How can we help them manage? Good question, Dan. Dan, do you have an answer? I do. Employers and employees need to be prepared to meet workplace needs when schools are open, partially open, or not open this fall. And here's some things to keep in mind. Employees who have not yet exhausted their expanded FMLA leave benefit under the Families First Coronavirus Response Act may take advantage of that opportunity when the school year starts. Their child's school district has partial or online only learning. Of course, this may result in some operational disruptions. Employees who choose not to send their children to school in districts that give parents a choice of in-person or online attendance are likely not eligible for expanded FMLA benefits because their child's school is not closed. But the Department of Labor has not addressed this issue yet. Employees may request teleworking arrangements, again, to accommodate online learning or partial week attendance at school by their children. And employees may also ask for flexible or part-time schedules to accommodate their children's education needs. All these things could be happening. Employers should consult their attorneys to confirm what arrangements are legally required and what would just be nice to offer to employees managing difficult circumstances. I do not have any young children in school right now. I do not know how people are doing it. It sounds very difficult. My hat's off to the folks out there who are managing it. And best of luck this fall, everyone. So Department of Public Works, upcoming webinars, articles you'd like to tell us about, Kathy? I'm sure you're going to tell people to check the Municipal Minute blog. You could read about that Hansen case you talked about on there. I've got Quorum episode number 44, the APA Illinois State Conference Planning Law Symposium, virtually live September 16th, 2020 at 10:45 a.m. My friends David Silverman, Shantae Rains from Hansel Glank, and the City of Aurora's Trevor Dick. We're talking about coronavirus response, religious land uses, and more. Hope to see you all there. Kathy, and thank you for all your comments today. Before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@ansoglink.com. And as always, you could visit us online at quorumforum.ansoglink.com. Kathy, can we get a motion to adjourn?
I so move.
Second, all in favor, the ayes have it. We'll see you next time at Ansel Link's Quorum Forum podcast. Thanks, everybody. Bye, people in the
Thank you.
stream.
Bye.